All right, well, welcome everyone to lunch, and we want to thank FGS Global for the lunch because this is a little better than your usual rubber chicken. So I hope everyone's enjoying it and enjoying the Four Seasons. So what we like to do at these lunches is not have a keynote speaker who just speaks to you, but have a government official interviewed by somebody so that we can hear a little bit more about what they're up to. And in this situation, this is my favorite kind of situation where you have the former chief of the unit talking to the current chief of the unit. And that's what we've got going on right here. So let me introduce these two people quickly. What you probably already know about Rob Cohen, he's the former chief of the SEC cyber unit. From crypto to cyber, Rob has done it all. But what you may not know is that he was also the former co-chief of the SEC's market abuse unit. And sort of like Christy Littman, as I mentioned before, he also ran the insider trading, market structure, manipulation, broker-dealers, alternative trading systems, exchanges. So he's really a two-way expert, which is so much different than, again, everyone here is always a little different from one another, as opposed to the SEC enforcement conferences, where everyone's kind of the same, worked at enforcement in the SEC and then went on to private practice. These are very unique individuals. So when I think of Rob Cohen, I can't help but think of is the Saul Goodman of incident response. Definitely the go-to player in lots of different ways, a jack of all trades. And then a very special guest, the most special guest we have of all today is Laura Delaire. She is chief of the Cyber and Emerging Technologies Unit, which was formerly the crypto unit and cyber unit at the SEC. From the Edgar Electronic Data Gathering and Retrieval Service at the SEC, to the Binance fraud. She has seen it all. And we really have to be grateful for her coming here today. It's very hard to get government speakers right now. You can appreciate why. What you may not know, the dramatic changes going on at the SEC. I talked about it in an op-ed piece in the New York Times on Friday or Saturday. They've stopped the entire crypto program, and Laura is charged with leading a new SEC where more than 20% have taken retirement. And it's just unbelievable how terrific she is at this job. And she's tough. She's the Ellen Ripley of incident response. And you know what? If she had a theme song, it would be Survivor by Destiny's Child. So let me turn it over to Rob, and let's hear what she has to say. So thank you. Let's give a round of applause to Laura for being here. We can't thank her enough.
Thanks. So I thought I would start by asking Laura to introduce herself and just sort of explain her professional background that brings her here to this new job.
Well, thank you, Rob. And it's great to be here with you all and to speak with you all. So to give you a little context and my background and where I come from, so around the first 8 years of my professional career as an attorney, I spent working at 2 different law firms in private practice. I spent a year clerking on the Fifth Circuit down in New Orleans. And then in late 2016, I joined the commission in our general core enforcement group. That was at the beginning of the last Trump administration. In 2017, I joined the cyber unit led by Rob Cohen here. So again, really great to be here with Rob. Worked in the unit as a staff attorney for a number of years, spent a year with our trial unit litigating a case called Kick. And then I spent about 7 months in our director of enforcement's office, advising him on cybersecurity and crypto-related issues. And then I had an opportunity around the time that the unit became the crypto asset and cyber unit to actually go and be an enforcement counsel to one of the commissioners, Commissioner Jaime Lizarga. And so I did that for about 2.5 years. And now I'm back in enforcement as chief of the newly announced Cyber and Emerging Technologies Unit.
Great. And those of us who worked with Laura earlier in her SEC career are not at all surprised that she has this new leadership position helping to run. The unit actually was created in 2017, as you said. It was renamed in the last administration under Chair Gensler, and was renamed and sort of reprioritized a bit a couple months ago. It's now the Cyber and Emerging Technologies Unit. Give us some background about the unit, just starting with, I don't know, facts, logistics. Who's in the unit? How many people? Where are they across the commission?
Sure. So as you said, we were originally formed. I'm going to give you like some background and context, and then maybe later we'll get into priorities for the new unit. But in terms of the background and context, as you said, we were formed back in 2017 as the cyber unit. In 2022, we were renamed as the crypto asset and cyber unit. And then very recently, we're only 2 months old, back in February of 2025, the commission announced the cyber and emerging technologies unit. That unit has around 30 staff members. So we've got 30 members consisting of fraud specialists. We have a whole group of fraud specialists in our unit, staff attorneys, as well as supervisors and the unit chief, spread out amongst a number of offices. So DC, our home office, our headquarters in Washington, DC, and then 5 other regional offices. And we also have a couple advisors to the unit, and they are in New York. So we're spread out.
Great. And I'll note, the unit had gotten bigger when it was focused on crypto. You said it's about 30 people now. If I'm remembering correctly, that's actually a little bit bigger than it was when it was first created. I think when it was first created, it was mid to upper 20s. So although it is smaller than it was in the last administration, I think it is similar size, if not bigger, than it was when it was first created.
Yeah. I haven't done a head count specifically, but that is correct. I mean, roughly we're around the same size, maybe a few people bigger than when we were the cyber unit. Yeah.
So as you said, let's talk about priorities. There was a press release. It had a bullet list of what the priorities of the unit were. What are you focused on? What are people in the group focused on?
So I kind of put them into, there was a press release. I put them into kind of 3 buckets of priorities that we are thinking about in the unit. So the first bucket it's a little new for us, and that is a focus on fraud across the emerging technologies space. So there we're really looking at weeding out bad actors who are misusing innovative technology or excitement around innovative technology to harm investors. And so that can include fraud related to AI or machine learning, as well as blockchain and crypto. And then we have a second set of priorities related to, probably most pertinent to this group here, cybersecurity compliance. So we're looking at registrant compliance with cybersecurity rules and regs like Reg SP, Reg SID, Reg SCI, as well as public issuer disclosure fraud. And then a third set of priorities I would bucket in other cyber-related misconduct. So that would include, using social media or fake websites or the dark web to engage in fraud, hacking to obtain material non-public information and trading on that MNPI, as well as account brokerage takeovers. So those are kind of the 3 buckets of priorities that we're focused on. And as you can see, there's some priorities that carry on from the cyber unit. There's some that are, have carried on throughout our history, and some new ones like with emerging technology.
And you've given some examples. Can you say anything else about what an emerging technology, is in this context? And so for one example, AI, it has been the focus, including at the commission, for at least a year or 2. It's not brand new. AI may mean different things to different people. There's people who are actually using AI. There's people who may be pretending to use AI. So how do you think about, what is an emerging technology in this specific context?
So talking about emerging technology generally, I'm glad you asked, because we specifically use that term for a couple purposes. We wanted to signify that we had both a broad remit in this unit, but also an evolving remit in this unit. This unit has evolved from its beginning, and it's going to continue to evolve. And so, emerging technology, what we think about in terms of emerging technology today is probably going to be different from how we see emerging technology, 5 or 10 years from now. So that term helps us, remind us that we need to be nimble. We need to keep a pace with innovation across the board. And, again, we're really focused, broadly speaking, on, when we think about emerging technology, our full mission at the commission. So we want to protect investors, of course, but we're doing that by also, we facilitate capital formation and market efficiency when we weed out those bad actors who are, stifling innovation, dragging down investor confidence. So, generally, when we think about emerging technology and the kind of cases and investigations that we're doing, we're looking at two kinds of buckets. One bucket would be folks who are actually using the technology, misusing the technology to engage in fraud, to harm investors, to harm investor confidence in these new technologies. So that can include, for example, using an AI model to engage in market manipulation. And another bucket would be what I, personally think of as emerging technology wrapper cases. So like instances where someone is using terminology, using excitement around a new innovation to actually just engage in good old fashioned fraud, so like old wine in a new bottle kind of idea. That's generally how we're thinking about it.
So on that latter point, I remember earlier in my career at the commission, solar was a big topic like that. People were using excitement about solar energy to attract retail investors into a fraud. And it really wasn't about solar, it was just using solar to attract them. So whatever the latest, greatest thing is that are getting retail investors excited, people are tempted to use that to try and separate them from their money. Okay, so we'll come back to cybersecurity in a second, but we can't help but touch on crypto. Again, from my perspective, crypto really dominated the unit and much of the enforcement division in the last administration. And so clearly between the crypto task force and public statements have been made, there's been an effort to re-steer on that. That said, as you noted, crypto is part of the mandate of the unit. So, what is your focus when it comes to crypto?
Yeah, so thank you for the question. And as noted in the press release, one of our priorities is fraud related to blockchain technology and crypto. We are looking to use our enforcement resources judiciously and where it makes sense. And here, we are focused on fraud on retail investors. It is worth noting the formation of the task force that was announced a few months ago as well. It's led by Commissioner Peirce. And when we were announced, our formation was announced, it was also stated that our work is going to complement the work of the task force. So that's what I can say there. We are focused on retail fraud at this time.
And I know there's only so much you can say on that, so I'll just sort of comment from the industry perspective that a key narrative from the last administration was that the commission's energy on crypto seemed to be focused on enforcement first. And there were, statements saying they wanted people to come in and talk, but because of the enforcement approach, I can say that, many in the industry did not feel that that was a realistic offer. It's very apparent from public messaging that there's an effort to, restart on that, to have, the crypto task force and the roundtables have a more open attitude to having people come in and talk. But at the same time, there is still an enforcement team that has a mandate and is supposed to complement that effort. So again, that's not a question. There's not much more you can say about that. But I'd say from the industry's perspective, that's something people are going to be looking at, and people are very excited about the new message and the mandate of the task force. But they're going to be watching that. That's of great interest. Okay,
Thank you for sharing. Actually, can I say something that I forgot to say?
This is your show.
So I didn't give my standard disclaimer, which I'm supposed to be, give at the.
Yes.
You had to ask.
I should have caught.
What's the thing that you struggle with as chief? It's remembering that disclaimer.
Yes.
So before we go any further, obviously my comments today are in my official capacity as the Division of Enforcement's chief of the Cyber and Emerging Technologies Unit. They do not necessarily reflect the views of the commission, the commissioners, or the commission staff. Sorry. And I think you were going to ask me about AI, and I'm happy to talk about it.
Yeah, so I apologize for not catching that up front. I should have. That's my job is.
I should have known.
I can't say moderator is only one other person up here, but pseudo moderator. So I'm glad you caught that. Yes, let's talk some more about AI. There's been AI washing cases. There's been AI public company disclosure discussion. There's been investment advisor using AI to give investment advice discussion. What's interesting in AI to you in your job?
Well, I would say we start with the anti-fraud provisions. So we're focused on the anti-fraud provisions, but we're looking at that across the board when it comes to AI. So, you mentioned AI washing before. You've mentioned, we can think about.
And I'm sorry, I don't mean to interrupt, but like AI washing, it occurs to me, but maybe not everybody knows exactly what that means.
Right. So, claiming, one way to define it would be, you're a public company and you say that you use AI in a certain way, or you're an investment advisor and you say you use AI in a certain way, and it turns out that you don't. Like maybe you don't use AI at all, or you use it in a way that you haven't disclosed, or say you use it in a way that harms investors. Then we're getting more into fraud directly on investors and harm directly to investors. So I would say we're focused across the board there, and we want to put our resources where it makes sense. We're always thinking about that. Wherever we see harm to investors, where we see there's a diminishment in investor confidence, right? As a result of that, like it may make sense, and if it aligns with the commission priorities, then it makes sense for us to be there. So we really are looking across the board on that. We do have in our fraud specialist group, we have a fraud specialist who is focused on AI. He comes to us from the exams division. And so he has a background looking at AI at various registrants and has a familiarity with the technology. And so he is really great. He helps us to triage cases. He helps us look at trends and help us focus our resources on where it makes sense. And we also provide consults throughout the division now on AI related cases. So we're kind of focused across the board on that.
So turning to cybersecurity, key topic of the day. There are some still relatively new rules on public company disclosures of cybersecurity. Before the new rules, there were no specific SEC rules on cybersecurity disclosure. It all fell within more general rules about disclosing material trends or material events or things like that. So now, for the first time, there are some cybersecurity specific disclosures. If I can ask you to briefly summarize them, but I would say the broader context or the broader question I would ask is, how do you think about the SEC's role when it comes to cybersecurity? Because it is not a cybersecurity agency. There are some of those. It is not a law enforcement agency. It's not a intelligence agency. It's mostly lawyers and accountants and some specialists. But that said, clearly cybersecurity is a focus for the commission. It has been going back at least a couple of administrations. Jay Clayton was very focused on cybersecurity when he was the new chair. So broad question is, how do you think about the SEC's role in cybersecurity? And not surprisingly, as part of that, what are these new rules?
Okay, so I'm going to take it, I'm going to flip it. I'm going to talk about the new rules and then talk about what we're thinking. So the new rule went into effect on public assured disclosure related to cybersecurity back in December of 2023. I think of it as having like two sets of requirements. So the first relates to Form 8K. There's a new requirement, item 1.05, on disclosing material cybersecurity incidents and disclosing, the nature, the scope, the timing, certain aspects of that incident. The requirement around that is to disclose it 4 business days after the company makes the determination that it is material. That's important to note.
Yeah, I would actually just not to interrupt, but like to sort of repeat that, because when we counsel clients, that's a hugely important and helpful distinction. It's not 4 days from the event. It's 4 days from deciding the event was material.
Yes, it's 4 days from deciding that the event was material, and 4 business days. So it is important to keep that in mind. And there are exemptions for that too. There's a national security exemption for that. If the Attorney General provides a notice in writing that disclosure would harm national security interests, for example, like there's an exemption for that. If you're a foreign private issuer, you would only be required to disclose if you're required to disclose in your jurisdiction, or you have already disclosed it, for example. So there's that requirement on 8K, and then there's a set of requirements related to Form 10K. One relates to what is the company's approach to the identification, assessment, and management of those material cyber incidents. Another set on what is the board of directors' role when it comes to material cybersecurity incidents. What's the expertise? What's the role there? Disclosure around that. In terms of our approach and what we're thinking about and what we look at, and you ask about, what is our role in cybersecurity? When you step back, the SEC, we're a disclosure regime. We're about disclosure. So what we care about is, are investors being provided material information so that they can make informed decisions, informed investment decisions. And so that's what we're focused on. And so, key to us, right, for you, for public companies is the materiality issue, right? Determining that something's material and then determining what needs to be disclosed around that. And when you think about materiality, what are we thinking about at the SEC? We're thinking about that Supreme Court standard on materiality. Would a reasonable investor, would there be a substantial likelihood that the reasonable investor would find that information important to his or her decision? Would it alter the mix of information available, right? Substantially alter it. So it all comes back to that. There's guidance in the release on the new rules. There's factors to consider like reputation, et cetera, but it really all comes back to that materiality. And one other thing I would note about that we're thinking about, right, is there's the 4 business days. There's the determination, right? Like you have to take time to make that determination, and there's a balance there, right? Like there can't be an undue delay, but you've got to have like a certain critical mass of information, right?
Yeah, and that guidance, I'll note, it's been very helpful in talking to clients. The guidance changed from the proposing release to the adopting release. And this is not in the rule text, it was just guidance in the commission release, which is pretty informative. Originally, it said, I think, as soon as reasonably practical, meaning the disclosure time period is from when the company determines something's material, and the proposed guidance was you have to decide materiality as soon as reasonably practicable. It was then changed in response to comments to without unreasonable delay. So as opposed to sort of an affirmative sort of like pushing, decide, as I view it, it was changed to a, look, don't artificially delay, right? Like, so we're not imposing a deadline on you, but don't game it. Don't sort of make sure nobody's talking to each other, so you're in effect not deciding. You can't do that.
Mm-hmm. I think, what might help here is for me to talk a little bit about, big picture, how we are thinking about these investigations and cases. And it may get into another question that you're going to ask, but I'm just messing up the order here.
No, go ahead.
So, but I think stepping back, when you think about cybersecurity, we are in this unit, in the commission, we're keenly aware of the challenges that public issuers and registrants face when they are a victim of a cybersecurity incident. That can be a difficult task, right, to think about what needs to be disclosed during that time. We're aware of that, and every company faces cybersecurity threats. We know that. And so what I'm leading up to here is that we, in the Division of Enforcement, in this unit, when we are looking at cases, we're looking at all the facts and circumstances. We're looking at the big picture. We are not looking to be a Monday morning quarterback. We're not looking to second guess, good faith, reasonable based like decisions. That's kind of what we're thinking about. We're thinking about the big picture, and that's how we approach it. And so when you think about unreasonable delay, or undue delay, what's the big picture there? What happened? You want to understand the context, big picture, what happened, what's reasonable, what's not reasonable.
That's terrific. And exactly, when the unit was created, 2018, there was a specific effort to publicly message the idea that the unit was not intended to second guess good faith decisions. And during the last administration, I think it's fair to say public companies that went through these types of investigations felt that approach had been abandoned. Reasonable minds might disagree on that, but I can say that was the feeling for firms that went through that process. And to hear you now talk about your perspective, I think is very helpful, and I think will be, people will wait and see what the enforcement actions are, but I think people are very optimistic about that.
Well, I'm not going to comment on the past, but I am going to say, what I said, that is the approach that we are taking.
Speaking of things you can't comment on,
why bring it up?
Because maybe you can say a little bit. So we only have a few minutes left, but we can't have this discussion without talking about the SolarWinds case. I know you can't. It's pending. I checked the docket sheet this morning to make sure. I didn't get a chance to say, oh, it's been dismissed. You can now talk. It's still pending, so you can talk about pending litigation, but you know, the SolarWinds decision was very prominent when it comes to SEC enforcement on cybersecurity. There were claims about a security statement posted on the company's website, not in SEC filings. There were claims about the company's SEC filings and its disclosures, and there were claims against an individual, a senior, security officer. On a motion to dismiss, interestingly, the claims about the SEC filings were dismissed. The claims about the statement on the website were not dismissed, and the claims against the individual, at least in part, were not dismissed because there were claims that he was involved in that security statement that was alleged to be misleading. The commission also had a number of controls charges, accounting control violations, disclosure control violations. Very significantly, I think, to the world of public companies, those were all thrown out. So a bit of a mixed result for the commission. Obviously, you can't comment on on pending litigation, but if we pick one thing from that got people's attention, I think it was the charge against a non-lawyer individual at a company for what was essentially disclosure violations. That got people's attention, and I can say I spent a lot of time on the phone with CISOs who were very worried about what this meant for how they do their jobs, where the essence of what they do is find weaknesses. So with that long wind up and understanding you can't talk about the litigation specifically, is there anything you can say on these topics?
Okay, we got 1 minute, 42 seconds. So you are correct. I cannot comment on ongoing litigation, and nor will I here. But I will say, on the topic that you raise on individuals, I can say something general. Look, when we look at individuals, look at individual liability, we're focused on the conduct of that individual. We're focused on what that individual did. And so if you've got an individual, generally speaking, and again, I'm not commenting on the case itself, but just thinking about generally our approach across the board, whether it's cybersecurity or anything else, frankly, when you're thinking about fraud and you're thinking about individuals, we're looking at the actions that individual took. We're looking at the involvement of that individual. And if you've got an individual that is, say, integrally involved in the fraud, then you can expect us to make a recommendation on that. Just as a general matter, I would say that. Are there other things you wanted me to talk about?
No, that's great.
Yeah.
We have half a minute. So two last things. I'll combine them. Use the time how you want. One is we haven't talked about regulated entities. There's rules relating to cybersecurity for broker-dealers, investment advisors, stock exchanges. That's within the unit's mandate. And then my last question was whether there's anything we haven't touched on that you want to share.
Okay. So really super quick on, regulated entities, Reg SP, Reg SID, Reg SCI, that's a mandate for us. We're going to continue to look at that. Big picture point there is that we rely on our division of exams for the most part. Like, they're the boots on the ground. They have the expertise to kind of initially, tell us and identify what's something that, warrants enforcement's involvement. There are a few caveats to that. Like, if there's a sign of, say a cybersecurity incident and there's insider trading, then we have a strong enforcement interest there. We may get more involved more early, but generally speaking, we're working very closely with our exams partners there. So I'll say that. And then...
And you definitely have the liberty to take another half a minute or minute.
Okay.
What do you want to end with?
I want to end with, something, we were talking about, you were chief of the cyber unit. Now I'm the chief of this new formation of the unit, the Cyber and Emerging Technologies unit, and kind of something that, has struck me about that, or has been new to me about it, new or unnew, or an observation about it, is that, we're in a time of transition. Of course, this is a new, it's an exciting time to be at the commission, in my view. And it is a time of change, but at the same time, something that stands out for me personally is, I'm kind of coming home. Like, I was a staff attorney in that unit, and now, to come back to it and to be in a position where, I'm the chief of the unit is really a unique and wonderful experience. We have a great group of folks, a really strong, tight team mentality, and it's been great.
That's great. That's great. Well, it's a great recognition for you, and I know that working on a new chair's priorities and what's important to them, and getting to help that from the ground level is a very rewarding professional experience. So thank you for doing it, and thank you for being comfortable coming here and talking to us publicly.
Thank you for having me.
Just fantastic, guys. And Laura, we're all congratulating you on a very well-deserved promotion and could not be more excited with you on the job. Thank you.